Good afternoon, Mr. Sardiwalla.
Good afternoon, Chief Justice.
Are you well?
Commissioners.
Are you relaxed?
Yes, I am.
Wonderful. Tell us why you believe you are ready for what you have applied for.
Chief Justice, I've been in practice as an attorney for almost 40 years with an extremely diverse practice, commercial, corporate, criminal, and of course the normal run-of-the-mill practice, giving me adequate exposure to the different facets of the law. I've done extensive work in the High Court, and I have also had the benefit of acting in the Eastern Cape, Durban on 2 occasions, well, 2 or 3 occasions, and of course up here in Gauteng. I believe that I have spent my time servicing myself, and that with the experience that I've enjoyed and have to offer, the time has come to give back a bit of what I have benefited over the years through the system and the judicial system.
Yes. Very well. JP?
Thank you, Chief Justice. Mr. Sardiwalla, you were in the Land Claims Court for a period of over 5 years, am I correct?
Yes.
Right. What did you do there?
I was in the court at Randburg initially at the instance of the late JP.
Yeah. Do you mind if I just interject here? All I want you to tell us briefly is what sort of work did you do, yes, without explaining.
Okay. Trials, urgent applications, inspections in local, appeals, a whole array of ESTA matters, labor tenant matters.
ESTA may not be known by everybody. We have, I think in this instance, I'm permitted to say we have honorable members here from Parliament who are not necessarily all lawyers. So what is ESTA? They may think you are talking about the woman.
Chief Justice, I hope I knew about that earlier on, but it is
yes, Mr.
ESTA is extension of Security of Tenure Act, which deals with the rights of occupants that are occupants of land, primarily in farming areas and farming communities.
Okay. So, in your stint in the Eastern Cape, how long did you act there?
I was in the Eastern Cape for approximately two or three terms. Let's get my notes out.
And what sort of work did you do there?
Everything, essentially crime. I was sent to the motion court, opposed motions, trials, criminal trials. I sat in Grahamstown as well as in Port Elizabeth. There I had exposure to some of the marine law matters, a full array of work that normally is one finds at the High Court. Okay.
So in the Gauteng division, you've done work in both courts, Johannesburg and Pretoria, am I correct? Yeah. And I see you've got 8 weeks of criminal trial work that you've done in Gauteng.
Yes.
Now, the work that you had to do in the Gauteng division and in the Eastern Cape division, I presume you acted in the Eastern Cape after your stint in the Land Claims Court, am I correct?
No, prior to my stint.
Prior to your stint, okay.
Yes, in Durban as well, prior to my stint in the Land Claims Court.
But what I want to find out is, did you find anything different, if any, in the work that the Gauteng division does, the nature of the work as in relation to what you did in the Land Claims Court?
I think there's a totally different nature and style of practice in the Gauteng courts. They're much busier. The pressure of work, the expectancy to deliver judgments and get the show moving is far greater than most of the other courts, simply because of the volume that one has in these courts.
All right. In terms of your judgments, you can correct me if I'm wrong. I've looked at the list of the judgments you've handed down when you're in Gauteng.
Yes.
I don't see anyone where you took longer than 5 months, unless I'm mistaken. The 5-month one is the number 14, Johan de Vet and Turner. I think that was 5 months.
Tutor, yes.
But I could be mistaken. Are there others where you took longer than that?
No, generally I try and deliver the judgments within a month, month and a half.
Yes.
I dictate my judgment, so the benefit that I have is that immediately after a trial I start dictating and try and deliver the judgments as quickly as I can.
Yes.
Those matters that may have been a bit delayed, a month or two delayed from the time that they were expected to be delivered, where as a result of the complexity, the kind of research that I had to do, they were not the run-of-the-mill matters.
Yes. Okay. My last question is, would it be fair to say from 2010 till current, you've virtually been doing a judge's job?
Yes.
Thank you
Yes,
very much.
I've been doing nothing else, but I don't have a practice. I have been acting in your division.
No, you did
And
more
the
in
Land Claims Court.
Yeah. Thank you, Chief Justice.
Thank you, JP. Well, I think before I forget, unless there is another Sardiwalla, there is a Sardiwalla who did the case of Mzolo versus Prasa. Judgment was reserved on the 22nd of April 2016 and has been reserved, according to my records, for 16 months. Are you the one or a different one?
That judgment has been delivered.
I beg your pardon?
I say that judgment has been delivered a while ago.
But for how long had it been reserved before you delivered it? Because I notice maybe the officers just failed to update the statistics, but it was reserved on the 22nd of April 2016. How long thereafter was it delivered?
It was delivered before the end of last term.
This year?
This year, yes.
That would have been how many months since it was reserved?
Yes, that was one that took much longer than the normal.
Well, I need to know how many months would it have been? Yes, I'll check.
What I have on my schedule, and subject to correction, but I've taken the schedule as extracted from the judgment. The date of hearing was the 23rd. This is Mzolo and Pasa, am I right?
That's correct.
Yes, 23rd of November 2016 and delivered on the 9th of March 2017.
So it wasn't reserved on the 22nd of April 2016?
No, not according to what I have here.
Well, it'll have, just make record of these things so that we can invest. So you would have delivered it within what? You say it was it in November?
About 4 months.
In 4 months' time?
Yes.
Very well. And then there is another. Is there a Sardiwalla J, or would they have been prophesying that you are a J when you were still a J, because I have a matter of Anna Regina Maoko versus Doran Bila, and according to my records, judgment was reserved on the 7th of November last year, which is 10 months by now. Are you the one who did it, or is it another Sardiwalla?
So, can I have the name of the judgment again, please?
Anna Regina Maoko, M-A-O-K-O, versus Doran Bila.
I must admit, I don't have
It's
this.
case number 41917/2015.
Chief Justice, I don't have that particular judgment in my list, and it doesn't ring a bell, to be quite honest.
You don't have such a judgment reserved.
On my list, I don't know of such a judgment, but I mean, if it's an omission, I don't know, but I don't have it on my list.
Okay.
I don't have that name at all on my list, and I don't remember such a matter.
You don't remember reserving any judgment for as long as 10 months?
No, no.
Very well. There is another, I think. Let me just go through my list and make sure. And this one of Salem versus Government of the Republic of South Africa.
Yes. That judgment took a long time.
But that's not the one that I referred you to earlier, is it?
No.
How long did you keep it reserved for?
That was
at the Land Claims Court, isn't it?
Yes, it's actually a groundbreaking judgment because it deals with land rights at a level which has not been dealt with in this country before.
Yes, I see that next to it you have written landmark judgment on restitution.
Yes.
Yes.
And it's been through the SCA and it's been before your court as well.
Yes.
For decision.
Yes.
That judgment took extensive research. The evidence that was led in that matter was over a period of 4 years in breaks and in the Eastern Cape. And there was extensive expert evidence in that matter. And yes, indeed, it did take longer, much longer for me to finalize that judgment because of its nature.
How long?
Certainly more than a year.
Are you able to estimate so that I have a fair sense of how long after the expiry of a year did you still have to take before it was finalized?
Can I get back to my...
Please. It's important. To me, this is all about court performance and one's ability to deliver justice within a reasonable time to the public. You see, that thing doesn't.
It was heard on the, well, over a period, in the last hearing was the 2012.
But reserved in, was that the last? I thought, I see 2012, 2013, so I thought you reserved judgment in 2013.
2013, yes.
And delivered it in 2015?
2014.
Is that
2nd of May 2014.
What is it there? Let me see.
I'm fine, Chief Justice. Thank you so much.
Okay, you delivered it on the 2nd of May 2014. Judgment having been reserved on which date in 2013?
I don't have the specific date. I just have date of hearing from that period to that period, but
Yes.
I don't have the specific date of hearing on my copy.
I don't understand, Mr. Sardiwalla. How does it happen that a judgment gets reserved for a year? An extremely complex matter. Even then, how does it happen that you move from January to December and you are working on a judgment? How does it happen?
Yes. Well, I agree it took a long time and it should not take such a long time. I mean, I concede that. But as I indicated earlier on, Chief Justice, the matter required a fair amount of research by myself, researchers, before I eventually delivered the judgment.
No, that I understand. Don't you have researchers at the Land Claims Court?
Well, we had a researcher, a temporary researcher, she was there for a while and then she was gone.
Okay, but quite apart from that, and mindful of the complexity of the matter and how long it took to finalize the matter, how does it happen that people have to wait for 12 months, more than 12 months, before judgment is ready for delivery? I'm just trying to understand. I don't want to assume to your disadvantage. I seek to understand.
Yes. There is no other reason except the fact that it was a very lengthy trial with volumes of evidence that one had to go through, and not just witnesses, but they were experts before finalizing the judgment, and because of the enormity of the judgment, it did take that long. And at that stage, of course, I didn't have the experience that I have now. And land claims was a relatively new kind of concept to me at that time, without the assistance of too many judges that were in that court to guide you along. The JP passed on, and we grappled before finalizing that.
You are not aware that you summarize evidence and make observations day by day as you go along? And two, you did not have the benefit of assistance from able counsel, heads of arguments?
Yes, of course, indeed I did.
Yes.
There was the benefit of heads of argument, comprehensive heads, but because of the nature of the matter, it took me much longer than I anticipated.
Yes. No, I understand. And I apologize that at this early stage I'm raising the matter so extensively. It's just something that troubles me.
Yes.
In the judiciary, that embarrasses us a lot when judges are referred to the JSC for misconducts relating to judgments that have been reserved for a long time. That's why I needed to give you the benefit of the doubt so that you can explain yourself.
Thank you. Thank you, Chief Justice.
Thank you very much, Mr. Sardiwalla. MEC?
Yes, I'm fine, Chief Justice. Thank you so much.
Thank you so much, MEC. Commissioner Nyambi?
Thank you, CJ. Afternoon, Mr. Sitwala. Mine is only one question. It's about the case of Ngobo, the criminal trial involving a rape of a mentally disabled child, 13 years old.
Yes.
I'll read part of the extract, then invite your comment about
Yes.
it. This crime, it's a bizarre as you can find them. Sometimes immorality is responsible for rape where there's a certain level of attraction caused by a female herself. But here we have the weakest of the weakest. A young child disabled. In fact, if there ever was the death sentence still available to these courts, it may well have been argued that this was an ideal scenario for that sentence. The court has an obligation to protect society from people like the accused and the behavior of this nature.
Yes.
Your comment about the dress code of a female and the issue of the death sentence?
Yes, let me just start with the dress code. And I think it would also refer to the aspect of the death sentence. In retrospect, when I looked at that judgment subsequently, and when raised by you, realized that both those comments were not becoming. I ought not to have made them. At the time, the nature of the matter that was before me was grueling. It was one of those horrible rapes of a little girl, and one sees that there is, despite the life sentence being imposed for rape, there is an ever increasing number of rapes in this country. It's unabated. And I think my comments were that if the death sentence was available, one may have argued that you were the appropriate candidate for it. But I think even that was wrong, and I must apologize. It was not the correct comment to make, because the death penalty was demolished. It was abolished, sorry, and demolished for very good reasons. For very good reasons. And as far as the second comment is concerned, I also think that my analogy that I used was a poor one. I should not have said that, because I believe it is my belief that everyone is entitled to dress in the way they're entitled to dress. You can't impose on an individual to dress in a particular way and expect that that person would be safe or not. It's a regrettable comment, and I'm embarrassed by it, and I now distance myself from the fact that I made those comments. So they were not good, and I've learned through that process to be more cautious. Subsequently, I've had a serial rapist judgment that I handed down about a month and a half ago. I've had another child, 6-year-old, raped by a middle-aged man. And none of those judgments talk at all to that kind of language, because I've realized that one must be restrained and cautious about these things, despite the fact that they are serious, very serious crimes.
Anything that you might have done in the past in relation to these two, with the hindsight, to address something of this nature besides the response today?
Well, there's not much I could have done, because it was on the judgment was handed down and it was on paper. It was my own regret that I sat with. I think the appeal court commented on it and corrected me on it, as I understand it, one of the two judgments.
Thank you, CJ.
Thank you very much, Commissioner Nyambi. Judge President Lope.
Thank you very much. Excuse me. Thank you very much, Chief Justice. I have one question for you. It relates to briefing patterns.
Yes.
I believe, obviously, black practitioners are on the receiving end. That's why I would like to ask you this question. I'm saying this being fully aware that the Department of Justice is doing something about it. The question is simply this: were you to be recommended by this commission today for a permanent appointment as a judge, do you believe that the judiciary should do something to ensure that black practitioners also have access to good work, which in turn will prepare them to be good judges of tomorrow? Or you believe it's none of our business as a judiciary, we must just stay out of it completely? Thank you.
It is absolutely imperative for judges, for aspirant judges, to be assisted and trained not only by the training programs that exist, but the type of briefing that is offered to aspirant black judges and practitioners. There seems to be a tendency of the lesser work being offered to black advocates and black judges, and the better work to the more senior non-black practitioners. And this must change. The pattern must be such that there's empowerment by those that are empowered.
Chief Justice, in your own words, is that not a form of discrimination?
It is.
Thank you.
Commissioner Msom.
Thank you, CJ. This is directly linked to the question that my colleague, Commissioner Nyambi, raised. And it arises from the comments that have been made by the GCP,
Yes.
because of the exact words that he quoted.
Yes.
And the question that they raise, and I think this is your opportunity now to address the broader South African populace, because they say those comments raise concerns about your, and I'm quoting them verbatim, the candidate's understanding of the Constitution and constitutional values. They raise concern about your understanding of the Constitution and constitutional values. How do you then allay the fears of the South African broader populace who may be concerned this afternoon that we are interviewing a judge who's got no, or a prospective judge rather, who's got no understanding of the Constitution and its values? Thank you.
Yes, as I alluded to earlier on, it is that those comments were unwarranted, and I regret them. I've certainly, and I'm saying this publicly now, hopefully this would get to the rest of the country, that I don't associate myself with any form of retrogression in our society when we've progressed so far from these issues. I subscribe to that, and it was done at a time when I obviously did not apply myself correctly at that particular time by making those comments, and I regretted them shortly after. When I looked at my judgment, I thought about it, and I said that they're most inappropriate. So I still do regret them, and I subscribe fully to the fact that we are in a democratic, independent, individual right society where a person has the right to dress as they please, to do what they please within the ambit of the law, and one can't go retrogress and make comments of this kind, and I still feel bad about it.
Thank you, Commissioner Msomi. Commissioner Schmidt.
Thank you, Chief Justice. Mr. Sardiwalla, I see that you've served on the Rules Board for the Courts of Law.
Yes.
You've served on the Committee drafting rules for civil jurisdiction and regional courts,
Yeah.
and many other positions.
Yes.
You've also consulted with Lord Wolf on review of the system in UK
Yes.
in respect to the Civil Justice Review.
Yes.
There's been some talk in the JSC recently about the necessity for uniform rules and practice directives.
Yes.
Do you agree with that sentiment?
I think that it's overdue. I think it's overdue. You know, my discussion with Lord Wolf at one of the conferences was most enlightening, because you know, they've moved a long way to access justice, and one of the aspects that have now, and I've been following this process through, one of the processes that has caught on like wildfire throughout the world is access, easy, cheap, quick access, mediation, alternative dispute resolution. You know, that is the route that the UK and most other countries are going, hand in hand with the judicial system, not an independent structure, but hand in hand auspices of the judiciary, those processes are where we are currently.
Which would, of course, require a coordinated approach.
Yes.
And you would be able to assist in that regard should you be appointed.
I have a passion for it. I've done extensive research, and I would give every bit of my time that is available to assist in a project of that nature. I serve with the Judge President on a committee that has commenced that initiative in conjunction with the Chief Justice, as I understand it.
Thank you, Chief Justice.
Thank you, Commissioner Schmidt. Minister?
Thank you, Chief Justice. Should I say Justice Sardiwalla, Acting Justice Sardiwalla. Good afternoon.
Good afternoon, Minister.
Am I correct to say that you served as, is it convener or chair of the Rules Board for a protracted period of time, well over a decade, I think, until recently, soon after my appointment, I think.
Yes. I served on the executive with the previous Chief Justice, Chief Justice Ngobo. I then served with Justice Nkabinde and Judge Somyalo on the executive of the Rules Board. And I chaired the High Court Committee on several occasions and various other committees, including the ADR Committee of the Rules Board.
And of course, that also includes you having pioneered and led the project that gave birth to what today is referred to as court-annexed mediation, which you still, a project which you still lead.
Yes, I can't take the credit for myself. It was the entire team that I led, and the efforts of people within the department, the judiciary, and all the heads that assisted me under your auspices, that we were able to roll out a pilot project.
Yeah. Maybe let me indicate that the contribution is most appreciated. But I want to take you back a little bit to this uncomfortable space from a different angle. In the Magistrates Commission, or rather Magistrates profession, there is a specialized training program called social context training. And that is to ensure that over and above ordinary judicial capabilities or competencies, judicial officers are prepared to discharge their roles within the context of the many social dynamics that prevail in our society. Do we have similar training for aspirant judges? And if not, do you think it would make any difference for aspirant judges if some sort of training of that nature would be offered?
As I indicated earlier on, Honourable Minister, that training is critical. It's just not necessary, it's critical. And training that is geared to the practical tasks that a judge has to deal with on a day-to-day basis within the constrained environments sometimes and the volumes. There needs to be training that assists not only with the legalistic aspects of it, but the practical aspects of judging. And I think it can do enormous benefit to aspirant judges and judges.
I'm referring specifically to social context training, if you get a sense of where I'm heading to. And this is in light of this anecdotal unfortunate remarks not necessarily being, in quotes, completely isolated. Maybe isolated, yes, but we've had a few incidents across the different strata within the judiciary itself. Put aside the profession, as in legal practitioners making remarks in court proceedings that are unfortunate.
Yes.
Would you agree that it is a challenge that the judiciary itself, in the context of the packaging of training, may need to be looked at?
I agree.
Maybe before he answers, Minister, if you don't mind, provide an answer on the understanding that it is part and parcel of the curriculum of the South African Judicial Education Institute to provide that training. It is being provided, so you can now answer with that understanding. It's just not compulsory, but it's being offered as a matter of course.
Well,
That's why my first question was, is this actually being offered? And I think he did not assist me, but thank you for the assistance from the CJ. Maybe I should have asked if you at any point have had the opportunity or privilege of being exposed to such training.
Yes, I've done the Canadian training program many years ago, and I found it extremely beneficial.
Canadian, you said?
Sorry?
Canadian, you said. Did you say Canadian training?
Yes, the training it was a Canadian South African program to train judges.
Oh, okay.
That I attended.
All right.
And I found it extremely useful.
Okay. Thank you very much, Chief Justice.
Are you referring to the one where Canada simply provided funding and we South African judges were doing
South African judges did the training, yes.
Okay. Thank you. Professor Ntlama?
Thank you, CJ. Good afternoon, Mr. Sardiwalla.
Good afternoon.
In section 4 of your questionnaire, you have not indicated whether there is any other thing that may embarrass the judiciary. I'm taking as with you have considered long before the Ngobo judgment that it is an embarrassment.
Yes.
But let's leave it there. Right, since you have been involved in the Land Claims Court on issues of land restitution, Section 25(7) of the Constitution limits the claims only to those who were dispossessed in June 1913. As an academic, I am of the view that this Constitution of ours creates a class of citizens as if the South Africans there were no South Africans who were dispossessed of the land before 1913. You are a judge. I come before you. Okay, it's fine, we can leave it.
No, can I answer to that? My judgment speaks directly to that issue. The Salem judgment questions the 1913 cutoff date. And we all know that communities existed before 1913. The Khoi and the San and the particular area, I'm talking about the Eastern Cape. And there was a movement of communities and they settled, these communities settled at different areas and moved along as and when the grazing was depleted. But many of the community members remained and established their own communities all the way before 1913. And they seem to be at limbo as far as their rights are concerned, because after colonization, those rights were totally removed. and ownership was given to the colonists. And of course, that resulted in another set of communities that worked for the colonists that came about. So the paradigm is so wide and so complex. And this is the specific issue that my judgment talks to, that one has to revisit the issue of the 1913 date and whether it meets the requirements of the expectations that we've created in the Constitution. It's a constitutional right to have your land returned. And that right, I believe, is being compromised by the way in which the legislation is couched.
Commissioner Norman?
Thank you, Chief Justice. Good afternoon, Judge Sardiwalla.
Good afternoon,
Yes,
Commissioner.
thank you. I wish to declare that I've appeared many times in the Land Claims Court before you, for the claimant sometimes and for the state sometimes. But I must say that I've observed you over the years, how you have treated the claimants who have no representation, how passionate and how empathic you've been towards them over the years. But you were asked by Commissioner Msomi, it was put to you, one of the comments that the GCP had made about the Ngobo judgment. But I would like to just draw your attention as well to paragraph 5.1 of the comment from the GCB, where it says the candidate's commitment to the values of the Constitution is most evident in his judgments emanating from the Land Claims Court, for example, the Salem decision. I'm just putting this just to say, as a person who's appeared before you and observed you numerous times, the way you treated the indigent, that I also concur with that statement. Thank you.
Thank you, Commissioner.
Thank you.
Thank you very much, Commissioner Norman. Commissioner Didiza?
Thank you very much, CJ. Good afternoon, Mr. Sardiwalla.
Good afternoon.
Mr. Sardiwalla, you have acted a long stint in the Land Claims Court.
Yes.
In your view, do you think, particularly on the matter of labor tenants, there is a way in which the issue of burial rights of labor tenants can actually be dealt with such that there is certainty on how that matter, will have to be dealt with going forward? Because it's one of those issues, as you know, that would always come up to the Land Claims Court, where those who are labor tenants are mostly refused by the farm owners to bury their loved ones on farms.
You're absolutely correct. Most of my Friday afternoons, Saturdays, and Sundays were taken up with urgent applications because there was a refusal to bury community members that have a burial site on a particular farm. It's a serious problem, and it creates, at a time of grief, it creates more grief when you are actually barred and gates are locked, and you are treated like in an inhumane manner, whilst simply trying to bury next to your appropriate forefathers or forebearers, which is a right. And these are the issues in the Land Claims Court that require urgent and pointed legislation to protect the rights of our people. It happens all the time. It's expensive enough to bury, but mourners must find money then to bring an urgent application on a Saturday to a court. It's just untenable in this democracy that we have to still put up with this kind of mentality. So there needs to be some kind of consultation between the respective communities, the owners, and appropriate legislation be put into place so that we stop this unnecessary inconvenience and hardship that people go through.
CJ, if I may ask my last question. With your experience in the Land Claims Court, and particularly the backlog on the resolution of the restitution cases, do you think the Land Claims Court should only be the one that deal with such matters, or maybe we need to reflect whether other courts shouldn't deal with these matters so that the issue of land restitution and land reform in general can be speedily addressed?
The Land Claims Court is bleeding. The Land Claims Court is bleeding. It needs help. It needs assistance to function. There are 2 or 3 judges, and they can do only so much. The volumes of outstanding cases have increased over the years, and given the nature of land claims, they are not matters that you can run in the way you would in a normal high court. There's inspections in loco, there's all sorts of expert evidence that's required, and matters run for years. In fact, I had a discussion with one of your members in recent times about the urgency of finalizing these matters, and a mechanism has to be found. There has to be a urgent revisiting of the legislation and the process by which land claims could be finalized.
Does that mean that the Land Claims Court must remain as a specialist court, or that it may remain, but other courts should also have the jurisdiction to deal with land claims?
Chief Justice, I think you've hit it on the head. The point is this: if the court cannot be supported adequately, given the financial constraints that we have in the country, we cannot simply allow one court to run land restitution. It needs to be spread around. It needs to go to other provinces so that there's provincial convenience for parties to litigate within the respective provinces, and perhaps appoint appropriate judges in those divisions to deal with the court, to deal with land claims matters.
The delays, are they at the level of the court or elsewhere?
Well,
in finalizing these matters as speedily as is humanly possible?
I think it's, Chief Justice, it is both ways. It is at the nature of the process of land claims, as well as the capacity to finalize these matters.
Yes.
It requires a very robust approach, which I've been taking in these courts.
A capacitation of the Land Claims Commissioner's Office and the increase of the number of judicial officers.
Yes, yes.
And the resources, you say, is it only judicial or also the research capacity?
Administrative as well.
Okay, okay, yes. President Maya?
Thank you, Chief Justice. Good afternoon, Mr. Sardiwalla.
Yeah. Good afternoon. I'm trying to find that face in the corner. Good afternoon, Justice.
I just seek clarity on an issue raised in the GCP comments relating to Normandian farms against Tumbeni, a matter in which you apparently were asked to recuse yourself.
Yes.
Does anything turn, there's no detail on this issue, does anything turn on this recusation application? What happened?
No, it was thanks for raising that matter, because it relates to a very complex matter.
Excuse me, Chief Justice. Supreme Court of Appeal on the 7th of November. This matter, yes, it will be before the Supreme Court of Appeal. Thank you.
Should I?
Well, if you comment, let it be in a manner that does not compromise you in any manner, in view of the fact that it's before the SCA.
Yes. I'm glad that it is before the SCA. It was an acrimonious matter with various sections of the law involved. Kara, Esther, labor tenants, and it had all the complications, and I'm glad it's before the SCA for decision.
But had you done anything wrong that points to why you had to recuse yourself or something? Or the suggestion that you should recuse yourself?
There was a pre-trial conference at which I urged the parties to take a particular approach in the interests of the Esther occupants and labor tenants. And there was vigorous opposition, and they felt that I had made up my mind. But pre-trial conferences and land claims normally settle matters, and I was trying to protect the respective interests of the weakest of the parties there. And they decided that I had already made up my mind.
Did you proceed with the matter?
No, I didn't.
Okay. Okay.
I indicated I recused myself.
Yes.
When I realized that they wanted to proceed, and I had engaged too far in the matter.
Okay. 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 Thank you very much, Mr. Sardiwalla. You're excused.
Thank you, Chief Justice and Commissioners.
Thank you.